Before the court is State of Ohio versus Ronald Conte. Each side will have 15 minutes to present their arguments. Kelly may reserve up to 5 minutes. Just let me know when you take the podium if you wish to reserve time and how much, and I'll do my very best to try to keep you apprised. Don't use the names of any children or minors. I don't think that has, excuse me, any applicability in this case. We have read your briefs and we are ready to begin.
Thank you, Your Honor. May it please the court. I don't need to reserve any.
I was just going to say, and you don't need to reserve anything because nobody's at the other table.
That would probably be disadvantageous to argue with myself, and talk myself out of what I want the court to do. Okay.
All right, go ahead.
Yes. There's a tagline or metaphor that sometimes you can't see the forest for the trees, and I thought of that as I was preparing for this argument this morning. Is that throughout this is the second appeal of the same parties. This court decided the case in Mr. Conte's favor last November. Then there was a rehearing, and we're back in front of the court again on the very same issue, and that is the trial court revoking his probation and sending him back to prison. And the metaphor is appropriate because throughout both appeals, there is not any supporting evidence in the record to establish the restitution amount, which was decided by the trial court at $1,500 per month. There was supposedly a hearing in April, and the result of that hearing was simply going on the record and saying now this court is modifying the original order of $2,500 per month to $1,500. But there was no financial records put in as testimony. Nobody testified that this was something that Mr. Conte could afford. And later on, it was proven that that amount was excessive because $1,500 per month is $18,000 a year. Mr. Conte, when he was released from prison in February of 17, started to work. He had 3 different jobs, and his total gross income for that year was about $17,000. So right off the bat, he was in a position where he couldn't meet the order, and he wasn't willfully not paying the $1,500. He simply couldn't do it. And he did pay whatever he could. He turned in financial summaries to the probation department, which satisfied them. What the trial court did and what Appley argued in their brief was they went through some expenditures because his records were subpoenaed by the prosecutor, turned over, and they looked at certain expenditures and said, oh, you paid more than the minimum on your credit card. You spent money on Amazon. You spent money on this, and these are not valid expenditures, and that money could have gone toward the restitution. But those were conclusions. There was nothing to say that those expenditures weren't valid. And obviously, if he would have bought a Lamborghini, that would be different. But
Mr. Williams, let me ask you something. And I know, in terms of all the expenditures, this is a minor one.
yeah.
What conclusion was the court to draw regarding Netflix?
That one I don't have an answer for. That one.
Fair enough.
I would say that I believe that was one of the expenditures that was made in April of 17, when, ironically, that's when he paid the full amount. I think what's not being remembered is he had been in prison for 21 months, was released in February. In April, he was still getting himself back together with his business and the other jobs. Some of those expenditures, he didn't testify at the hearing, but some of the expenditures that they claimed were misspent could have been business expenditures. I can't put into the record something that wasn't at the record, but I believe that those, at least 2 of those expenditures that they complained were not valid, were in fact for his business. There's no contrary evidence to show that it was spent on him personally.
Could there have been?
I'm sorry, Your Honor?
Could there have been? Did he have the opportunity to show that they were in fact business-related expenses for his accounting and what he was doing at that time?
If there was a strategic decision made at the second hearing not to have him testify, the reliance was put upon the fact that he had come up with a repayment plan to try to get the victims their money, and a number that he could validly meet each month and each year, so we wouldn't have any more problems. It was believed that him testifying in light of everything else that had gone on with the particular trial court judge, that it would not be advantageous to have him take the stand.
And was that, the payment plan you hoped to establish, was that something different than the 1,500 previously?
Yes, it was. It was a bifurcated plan of a certain minimum, I believe, of $9,000 per year, but it was weighted toward the tax season. During the tax season, January to April, he would pay a larger amount, and then he would pay a certain amount each month. But by the end of the year, it would equal the stated amount, whether or not each month may not have been the same. Because one month he may not have only been able to pay $250, another month he could have paid $2,000. But we structured it so that at the end of the year, he had to pay X amount of dollars, and if he didn't, then his probation could be revoked.
Just for my curiosity, I'm sorry, is that on the record?
Yeah.
Get that off, okay, thank you.
It was, we had filed a motion with an attachment, and it also listed the expenditures that he had to make to try to show the court that this is what he's going to spend his money on. Another issue that was done in both decisions by the trial court was the use of his wife's assets and saying that, well, because she owns this building or because she has a certain amount of income, that money could be attributed or possibly used for reimbursement, for restitution. And there's case law cited in my brief that is making a spouse pay for the debt of another. That's not legally permissible. The court did it twice.
The court found, did it not, that there's no evidence that she was the owner of that, the sole owner of that building?
As part of the exhibits, Your Honor, that was submitted to our hearing, we had the records from the Summit County Fiscal Office that listed her as the owner.
If I may, even if that's the case, she was getting that income while he was in prison anyway. So she was sustaining herself while he was in prison.
That's
anyway.
correct.
So when he comes out, really the only extra added expenditure would be his food.
Well,
Really.
he would have to spend for, well, you mean her extra expenses?
Yeah. And the reason I'm asking that is because you just told me that his gross income for 2017 was about $17,000. The restitution would have been $18,000, so the difference would have been $1,000 there. He would have been short $1,000 had he paid it. He really only paid according to the judgment entry, and this is what the judgment entry says, whether the record reflects it or not, I don't know, but according to the judgment entry, he paid $3,315 over 9 months, which averages about $400 a month. So if he paid what he was paying. So my question is, he made about $17,000. He only paid $3,300 according to the judgment entry. What happened to the other $13,685?
Well, some of it was payroll taxes. I mean, he was a 1040 employee, so there were payroll taxes taken out.
That evidence is in the record?
Yes, because he turned in a summary of all the months that before he was incarcerated in October 17, each month that he was out, he turned in what he made, turned in his pay stub, and then listed the expenditures that he made. Some of them were for food, some of them were for clothing, some of them were for car insurance. He had his own credit cards. You know, there may have been, Judge Callahan pointed out Netflix. That was probably a mistake to pay that instead, or to get that. But a person is allowed to live, and the fact that he had $17,000 of gross income doesn't mean that every single penny was supposed to go for restitution. Not denigrating the fact that he owed a lot of money. There were a lot of people harmed by his theft of monies. But a person still is allowed to live, and it seemed the court did not take that into consideration. And in fact, we had argued in our brief that they were cherry picking some of the expenses. The other argument in terms of assuming that he didn't properly account for his money, that he was not paying everything that he should have paid or could have paid, Bearden v. Georgia says that before the court can revoke someone's probation and send them back to prison, that there has to be a reasonable alternative and only when that reasonable alternative wouldn't be satisfactory to the protection of the public should the person go to prison. We gave the court a reasonable alternative. We're saying this is what he can make, and the court didn't even take it into consideration. It was just summarily dismissed.
Let me ask you something, counsel, because I really had to look that over, and I'm open to your interpretation, although I think I know what it is. It seems to me that the trial court read that as though you can find it willful, or if not, there has to be a reasonable alternative. It looks like the trial court's entry simply did that first part, put whatever she felt was appropriate, put on the record, be it cherry picking or not, and I understand what you're saying, and found it willful. Did she need to go to that other alternative?
I believe so. I mean, that's my interpretation of Bearden v. Georgia, is that if someone is not doing what they're supposed to be doing, the court can make that determination, but then before we send this person to prison, especially, you have multiple victims here who were out hundreds of thousands of dollars because of his admitted misuse of the money that they were paying for taxes, which didn't go to pay the payroll taxes. We've had, now it's going to be 2 years next month of him being incarcerated and not a penny going to any of those victims. The court, in its commentary and the multiple hearings that I had in front of the judge, that seemed to be a focus of these victims aren't getting every penny that they should get. The prosecutor would argue vehemently and vigorously, as they should, that the poor victims aren't getting anything. How does summarily saying, we think you're being willful, we think you're misspending your money, we're going to not even consider an alternative at a lesser amount, but an amount that I will say I will pay at risk of going back to prison. How does that help any of these victims if that was the court's intent? That seemed to be why the court sent it back to prison. You're not doing what you're doing, the victims aren't getting any money, so now I'm going to send you to prison. To me, that doesn't make a whole lot of sense, but perhaps the court had reached a point of frustration, but there still is lacking a real finding of willfulness. The court made it, and the court pointed to things in the record which wasn't done in the 2017 decision, but when you look at how the court made the finding and look at the arguments that we made and the other aspects of the record, including the probation department, 2 probation officers testifying, we see this guy every month, and we don't find any evidence that he's trying to hide anything or not meet his obligation. There still was a lacking a finding of willfulness. And if you don't have that, then that was abuse of discretion, and the trial court decision should be reversed, and that's what we're asking the court to do.
All right, thank you, Mr. Witness.
Thank you.
We will take this matter under advisement, issue our written decisions, which will be released